You touch down at JFK after months away. 5 months since you left your place, your job, your daily routine. You're exhausted, fighting jet lag, and all you're thinking about is getting through the airport, into a cab, and back to your normal life. You walk through the terminal like you've done before, line up at immigration, and when it's your turn, you hand over your green card. The officer scans it. You expect a quick check and a welcome back. Instead, the scanner beeps. The officer pauses, stares at the screen for a moment, then looks up and says the sentence every traveler dreads. Please step to the side. A second officer appears with a small tablet and points you toward a camera. Look straight ahead. Don't move. No smiling. A flash. Your face is captured. It feels like just another security formality. But that image is more than a simple photograph. It's part of a biometric tracking system that is now logging every time you enter or leave the United States. And over the last several months, that system has started doing something many permanent residents weren't prepared for. Green card holders who thought everything was fine are being flagged as soon as their card hits the scanner. A red mark shows up on the officer's screen. Next to their name, a number appears. 183 days. 190 days, sometimes more. And within moments, the officer asks a question that can change everything. Why were you outside the United States for so long? What happens in the next few minutes can determine whether you walk out of that airport and go home, or whether your card is taken and your status is suddenly in doubt. A lot of people assume the danger is the camera itself. It isn't. The real risk lies in what the system already knows before anyone says a word. The moment your document was scanned, the computer pulled your complete travel history. Every departure, every arrival, every day you've been outside U.S. borders. Once your total time away passes certain benchmarks, the focus of the inspection changes. What began as normal entry processing can quickly turn into a residency review, an informal inquiry into whether you still truly live in the United States in the eyes of immigration law. And here's the part that surprises many people. At that initial moment, the officer doesn't need to prove anything. Instead, they ask questions. Nervous, tired travelers trying to be open and explain themselves often start talking in great detail about family problems, business issues, or emergencies abroad. They think that being fully transparent will help, but inside an immigration booth, every statement can be written down and interpreted under the law. What feels like a heartfelt explanation to you can become a line in a report that suggests your real life may be somewhere else. That's how a simple arrival can escalate into a secondary inspection, paperwork you don't recognize, and questions you never expected, all triggered by a system that began operating quietly at the end of last year. If you're a permanent resident, or you plan on spending a long stretch of time outside the U.S., you need to know what changed, why it matters, and what you can do before you ever reach that booth. Because the technology in use at U.S. airports now isn't just confirming your identity. It's measuring your time away. And the difference between a routine welcome back and a serious problem can be as simple as how that information appears on a screen. I'm Timothy. In this video, I'm going to explain what's happening at U.S. airports under the biometric entry-exit rules that took effect at the end of 2025. These updates sound like technical details, but they're already affecting green card holders returning from longer trips, especially those who stayed abroad beyond what they originally intended. We'll go through what this biometric system actually does each time you cross the border, why permanent residents are being flagged more easily, and how immigration lawyers say you should handle questions so you don't unintentionally damage your own case. A lot of permanent residents have the wrong idea about what actually puts a green card at risk during travel. Some believe there's a rigid 6-month rule where one day over equals automatic loss. Others assume that simply having a green card guarantees trouble-free reentry. Neither is fully accurate, and the new biometric tracking makes it much easier for officers to see when your travel patterns raise questions. Once you understand how the system works and how absences are evaluated, it becomes much easier to stay calm, answer correctly, and avoid creating problems where none needed to exist. To see why this is happening more often now, you have to go back to a rule that quietly took effect on December 26, 2025. On that date, the Department of Homeland Security expanded the biometric entry-exit program. For years, the U.S. collected fingerprints from many arriving travelers, but the new rules go far beyond that. Now, facial recognition is standard. Every time a non-U.S. citizen enters or leaves the country, a facial image is captured and linked to their record. That includes tourists, students, temporary workers, and lawful permanent residents, green card holders, groups that were once sometimes exempt, such as younger teens or older seniors, are now typically included. From the government's perspective, the goal is straightforward. Create a consistent way to verify who is entering and leaving, and keep a precise record of when it happens. On the surface, that sounds like a security upgrade, but for green card holders, the impact comes from how this data is stored and used. Every time your face is scanned, the time, place, and event, entry or exit, are logged. The system adds that event to your long-term travel history. Over time, it builds a clear timeline of how long you've been. Inside the U.S., outside the U.S. This doesn't rely on stamp dates or handwritten notes. It's automated, and the data isn't thrown away quickly. Under current policy, biometric entry-exit data can be retained for many years, in some cases decades. That means each crossing you make becomes part of a durable digital record. For visitors, this helps identify people who overstayed short-term visas. For students and workers, it helps check compliance with program rules. For permanent residents, it's linked to a separate legal expectation, that your main home is in the United States. That expectation has always been part of green card status. The difference now is how quickly officers can see whether your recent travel patterns look consistent with living here or look more like living somewhere else. Today, when you hand your green card to the officer, they scan it and the biometric photo confirms your identity. The system instantly shows your last exit and entry. It calculates how many days you've been away. If you were gone just a couple of weeks, nothing unusual appears. But if you were gone 170, 180, or more days, that number is front and center. The officer does not need to guess or ask you to estimate. It's right there. At that point, the focus often shifts from "who are you?" to "what does this absence mean?" This is where the myth of the 6-month rule shows up. Many people think, if I'm out for more than 6 months, I automatically lose my green card. That is not an automatic on-off switch. There's no instant cancellation at day 181. But crossing that threshold does often prompt questions, because under the law, the government can start asking whether you are still genuinely residing in the U.S. In the past, this was sometimes fuzzier. If passport stamps were unclear or dates weren't obvious, officers spent more time just figuring out how long you'd been gone. Now, the system already knows. That frees them to immediately ask the next question: why were you away that long? If you've been out for half a year or more, that question can appear on their screen as a prompt to dig deeper. From the traveler's side, the most natural thing to do is try to explain everything. You might say, "My mother was ill, I needed to help. I had to manage property or business abroad. Flights kept getting canceled and delayed." All of which can be entirely true and understandable on a human level. But from the officer's side, every one of those answers gets reduced to a short note, for example. Stayed abroad to care for relative. Maintained business overseas. Extended stay due to ongoing obligations abroad. In immigration law, those short phrases can sometimes be used to argue that your main life, your responsibilities and ties, is now outside the U.S., especially if you don't clearly and repeatedly reinforce the idea that your permanent home remains here. On top of that, you may be tired, stressed, or anxious. Under pressure, people tend to talk more than they intend to, share more detail than is needed, and sometimes give answers that are complete but not strategically helpful. That's why many immigration attorneys say one of the most common mistakes at the airport is talking too much. Not because you should hide the truth, but because long, emotional stories aren't how the law evaluates your status. The law looks at patterns and anchors: where you work, where you keep a home, where your immediate family lives, how you file your taxes, and whether, even while abroad, you always plan to return to the U.S. as your main home. That broader analysis is called the totality of the circumstances. It's meant to prevent someone from losing permanent residence based solely on one long trip. Judges and officers are supposed to look at the overall picture, not just how many days you were gone. They may ask, do you have a job or ongoing employment in the U.S.? Did you keep your lease or mortgage here? Did you file U.S. tax returns as a resident? Are your spouse and children living in the U.S.? Did you intend your trip abroad to be temporary? If the answers show strong ties to the U.S., that can weigh heavily in your favor, even if you were away longer than you intended. The challenge is that the first impression often comes from that quick conversation in front of a booth, when you're tired and the officer is typing your words into a system. If your initial answers focus almost exclusively on what kept you outside the U.S., but you barely mention your ongoing life here, the initial record may not reflect the full picture of your situation. That's why many lawyers recommend a simple communication strategy. Always answer truthfully. Keep answers short and on point. Emphasize that your home is in the United States and your trip was temporary. You don't need to recite legal phrases, but you do want your responses to consistently reflect that. You maintained your U.S. residence, you intended to return, and your main ties are still in this country. Now let's talk about how this looks in practice. You reach the counter, your card is scanned, the biometric photo is taken. The system pulls your travel data. The officer begins with basics. What's your name? What's your address in the U.S.? Where are you arriving from? You answer directly. No extra detail, just clear information. Then the officer says, I see you were outside the U.S. for about 6 months and 2 weeks. Why were you away so long? Instead of launching into a long story, an attorney might suggest an answer like, I was visiting family, but my home and life are in the United States, and I always intended to come back. If asked what ties you have here, you mention briefly, I work in the U.S., I have a home here, and my family is here. Short, accurate, and focused on residency. Sometimes that's enough. Other times, especially if the absence was lengthy, the officer may decide to send you to secondary inspection for further review. Hearing secondary can be alarming, but it doesn't automatically mean your card is being taken. It means another officer will spend more time reviewing your case in a separate area. In that room, they may ask more questions about your job, home, and family. They may check other databases. They may print or review documents. This is also where you might encounter paperwork. One form in particular is especially serious: a document for voluntary abandonment of permanent residence. This form, when signed, tells the government you are choosing to give up your green card. Some people do that intentionally when they have fully relocated abroad and no longer want U.S. tax or residency obligations. The danger is when a tired, stressed traveler signs it just to get out of a difficult situation, without understanding that they are ending their status voluntarily. Immigration attorneys consistently warn, do not sign any form giving up your permanent residence unless you truly intend to do so, and you've had a chance to get legal advice. If such a document is presented and you do not want to abandon your status, a calm response might be, I do not wish to give up my permanent residence. I want to keep my status and would like to speak with an attorney before signing anything. That statement is respectful, clear, and protects your rights. If the government believes you may have abandoned your residency but you disagree, another important protection exists: the right to have the case reviewed in immigration court. Permanent residents generally cannot be removed based solely on a quick decision at the border if they contest the allegation. Instead, the case can go before an immigration judge, who will look more thoroughly at your travel history, your ties to the U.S., your stated intentions, and the entire pattern of your life. In many cases, people who faced tough questioning at the airport were later able to show a judge that they maintained strong U.S. residence and did not intend to abandon their status. That's exactly why understanding your rights and staying calm is so important. All of this is happening against a backdrop of rapidly evolving technology. The biometric entry-exit system is one visible part of a larger move toward data-driven border control. Over time, these systems are likely to become even more integrated with other government databases. For green card holders, that means long absences will be easier to see and analyze. Patterns of travel may draw attention faster. Questions about residence expectations may arise more often when trips are extended. This doesn't mean you have to stop traveling. Life will always involve family emergencies, important events, and obligations abroad, especially for people with roots in more than one country. What it does mean is that planning matters more than it used to. If you expect you might need to stay abroad for a long stretch, immigration attorneys often recommend considering a reentry permit, Form I-131, before leaving, especially for trips that may last a year or more. Keeping strong, documented ties in the U.S., job, home, taxes, bank accounts, and family, being aware of how long you've been away and how that might look when you return, speaking with a qualified immigration lawyer before or after extended trips, so you understand your specific situation under current rules. A reentry permit doesn't guarantee you won't be questioned, but it does show that you planned the trip as temporary and informed the government in advance. Ultimately, what we're seeing is a shift from a system that relied heavily on questions and memory to one that leans on precise travel data. From the government's perspective, it's about efficiency. From the traveler's perspective, it puts more weight on preparation and awareness. The good news is that knowledge changes the experience. You walk off the plane, you approach the counter, your card is scanned, the system knows how long you were gone. If that time is long enough to raise questions, you're ready. You know your status, you know how the law views residents, and you know how to answer in a way that is truthful, calm, and clear. You don't need to argue. You don't need to panic. You simply confirm your ties to the U.S., explain that your trip was temporary, and if things escalate, avoid signing anything you don't fully understand. This information is general and is not a substitute for personal legal advice. If you think your situation might be complicated, the safest course is to speak with a licensed immigration attorney who can look at your exact facts. If you know other green card holders who travel frequently or who may need to spend extended periods abroad, consider sharing this with them. Many people only learn about these issues after a difficult experience at the airport, when options are more limited. Staying informed, planning ahead, and understanding your rights are the best ways to protect your status and your future in the U.S.